welcome to our July 2020 Commercial Cannabis Permitting Workshop. I'm Public Information Officer Janice Mackey from the California Department of Fish and Wildlife. We have a lot to cover today. You'll be hearing presentations from the State Water Boards, Fish and Wildlife, the Franchise Tax Board, Cal Cannabis Cultivation Licensing, which is a division of the Department of Food and Agriculture, among other important state agencies who have some great information to share with you. If you have questions about the content in any of the presentations, you can submit them to askcannabis@wildlife.ca.gov. That's askcannabis@wildlife.ca.gov. Questions will be answered at the end of the final presentation. With COVID-19 restrictions in place, our presenters are at different locations and dependent upon local and home internet connections, which are not always reliable as we'd like them to be. If for any reason a speaker goes silent, please be patient. We will give the presenter a few minutes to fix the technical issue before moving on. We appreciate your understanding on this matter. Lastly, today's workshop will be recorded through the final presentation, but not including the submitted questions. The recorded presentations will be available and/or advertised on the Cal Cannabis, Fish and Wildlife, and State Water Board web pages and/or social media outlets in a few weeks. So if you missed anything, you will have a chance to hear it again. Be sure to like, follow, and subscribe to listservs at these sites. Thanks again for attending, and now let's begin.
Hi, my name is Lsa Santos, and today I will be providing an overview of Cdfa's commercial cannabis cultivation licensing process. Next. Currently, we have over 5,000 approved applications. Here you will see a list of the top 10 counties and the number of licenses issued to each. Next. Of these licenses, about 29% are designated as medicinal, while 71% are designated as adult use. Next slide, please. On this slide, you will see a breakdown of these licenses issued by size. Yellow representing the majority of the licenses issued as small, which is about 64%. Next. Here you will see a chart illustrating the type of licenses issued. Mixed Light Tier 1 has the highest percentage at 37%. This is a license type which includes light deprivation. Next. This is a map of California showing annual licenses issued as purple and provisional licenses issued as blue. Next. As for our division structure, Cal Cannabis Cultivation Licensing is made up of the licensing branch, the compliance and enforcement branch, and the administrative branch. Next. This diagram shows the annual license application review process. First, the applicant must submit an application with our department and pay for the application fee. Once we receive the application, it goes through local verification. This is where an email is sent to the local authority to determine local compliance. When the local verification is complete, the application goes through administrative review. This is followed by scientific review, and when an application is approved, a notification will be sent out to the applicant to pay their license fee. The license fee must be paid in order to issue your license. Next. Local verification consists of address validation to confirm physical addresses using mapping software. It also deals with the transmission of compliance inquiries, where the local jurisdiction will have either 10 or 60 days to respond regarding the applicant's local compliance. The compliance responses are analyzed and will determine the next step of processing. If we receive a response of incompliance, or if the local jurisdiction does not provide a response within that time frame, the application moves on to admin review. If we receive a response of non-compliance, then the review is stopped at that point and the application may be recommended for denial. Next. Here we move on to administrative review. We look over the business entity structure information provided in the application, such as business formation documents. We also look at right to occupy documentation, which includes titles, deeds, and lease agreements. Owner applications are also reviewed as part of the admin portion, which includes things such as criminal history and conviction disclosures. During this review of the application, there may be some deficiencies, and if there are any, you will have 90 days to supply all missing information. Next. Following the admin review, we have the scientific review. Here we look at CEQA compliance and cultivation plans. We also review information relating to the enrollment in the State Water Quality Protection Program, LSA agreements, and water source information. All documentation submitted relating to CEQA compliance and LSA agreements are used to decide whether or not that license will be a provisional cannabis license. During the scientific review, you will have another 90 days to resolve all deficiencies that have been identified. Next. Once the application is approved, the applicant will have 90 days to pay their license fee and receive a cannabis cultivation license. If the license fee is not paid by that deadline, then the application will be disqualified. Those who have not paid their license fees cannot legally cultivate or engage in transfer of product. Next. Let's briefly talk about CEQA. CEQA stands for the California Environmental Quality Act. Cannabis works with the local jurisdictions to determine CEQA compliance. The local jurisdiction may opt for a statutory exemption for their local ordinance. Full discretionary reviews include categorical exemptions, tiering checklists, and others. Ministerial exemptions alone are not enough for us to issue state licenses. Next. Now let's get a little more into provisional licenses. These require all the same components as the annual cultivation license. Again, CEQA information provided in the application is used to determine whether or not the license is to be provisional. But for provisional licenses, you must be able to show that CEQA compliance is underway. Local verification is done to ensure you are engaged in the process. I'd like to also note that there is only one application for a commercial cannabis cultivation license. Annual and provisional licenses use that same application. Cdfa will be the ones to determine if the applicant will receive a license that is provisional or annual based on their review. Next. So what happens if you need to make any changes to your license after it has already been issued? That's where amendments come in. First, let's talk about administrative amendments. To request an admin amendment, the DRP will need to send an email to the email listed on this slide. In the email, please include the license number you wish to amend, any supporting documentation for the desired amendments, and what information is specifically being amended. These emails should only contain amendment requests. So if you have any other questions, please send an email to our other inbox at calcannabis@cdfa.ca.gov. Next. Science amendments are a little different. You can submit science amendments directly through our licensing portal. This includes any physical modifications to the licensed premises, requests to transition from a provisional license to an annual license, and provisional license renewal reviews. When logged into the licensing portal, please locate the license you wish to make changes to and click on the link that says Amendment. This screenshot is an example of what you would see. When transitioning a provisional to an annual license, next slide, the expiration date of the existing license does not change. Transitions can be done at any time, and the licensee must meet all regulatory requirements, which include CEQA and LSA information. And the request to transition must be submitted through a science amendment. Next. When it comes time to renew your license, if you go into the licensing portal and navigate to your list of licenses, you will notice a link that says Renew License. You can renew your license starting 60 days prior to your expiration date, and this button should activate at that point. License renewals are automated in the system. You will need to follow all prompts and pay all necessary fees, and the system should issue your license. Next. When renewing your provisional license, you are also required to submit a science amendment. You will need to provide proof that you are making progress on any outstanding deficiencies and other agency permitting requirements. If all information is not submitted, then these licenses may be subject to a licensing action. Next. For provisional license renewals, please make sure to submit a science amendment prior to your renewal application. All license fees are due at the time the licenses are renewed for both annual and provisional renewals. Next. Now let's talk about track and trace. CCTT stands for California Cannabis Track and Trace. Licensed cultivators are required to report the disposition of immature and mature plants, non-manufactured products, transfers, and waste. UIDs are required for tracking and tracing plants and packages, and these UIDs are provided at no cost to the licensee. Next. Licensees with an annual or provisional license are required to use the CCTT system and must complete the required training prior to gaining access to their system. Next. All activities such as waste produced, plants harvested, and packages created must be reported in metric within 3 calendar days. Cdfa's Compliance and Enforcement Branch is revoking licenses for cultivators who are delinquent in completing their CCTT requirements. Next. Compliance ensures licensees are compliant with regulations and cultivation plans. Contracts with county agricultural commissioners are used. Multiple inspections are conducted per year. Notices of noncompliance and notices of violations are utilized. And there is a possibility of license revocations. Next. Enforcement focuses on unlicensed cultivation sites. They take action based on recommendations from local law enforcement and permitting agencies. Next. And that concludes my portion of this presentation. This slide right here includes all contact information you may need, so feel free to call, email, and follow us on social media. Thank you.
Good morning, everyone. My name is Kyle Stoner. I am a senior environmental scientist specialist with the California Department of Fish and Wildlife and the cannabis program out of the North Central region. We're centered around the Sacramento area. And today I'm going to present to you information about permitting for cannabis cultivation with the department. Next. The department's mission is to manage California's diverse fish, wildlife, and plant resources and the habitats upon which they depend, for the ecological values and for their use and enjoyment by the public. So one of the tools that the department uses in law is the Lake and Stream Alteration program. The authority lies in Fish and Game Code section 1602. Next slide, please. And that section states that all entities must notify CDFW before beginning any activity that may substantially divert or obstruct the natural flow of any river, stream, or lake, substantially change or use any material from the bed, channel, or bank of any river, stream, or lake, or deposit debris, waste, or materials containing crumbled flake or ground pavement where it may pass into any river, stream, or lake. Next slide, please. So in the code, it states any river, stream, or lake, which would include perennial streams which flow year-round, intermittent streams which flow seasonally and are dry for periods of time, and ephemeral streams which carry water only during and immediately after precipitation events. Next slide. So the reason that cannabis cultivators have to submit a notification of lake or stream bed alteration regardless of the presence of streams on site is the Cdfa regulation requiring all applicants, including a final lake or stream bed alteration agreement or written verification that an Lsa agreement is not required. Next. So the department determines, once notification has been submitted, the department determines if an agreement is required by reviewing the project description to determine whether the project may substantially adversely affect existing fish or wildlife resources. Next. So example activities that may require an agreement include water diversions or impoundments, stream crossings, bank stabilization, channel or lake bed modifications, vegetation management, or in-channel maintenance. Most commonly for cannabis cultivation, it's usually stream crossings to access cannabis cultivation sites. Next. So how do you get an LSA agreement or verification that one is not required? You're going to start by visiting our cannabis program website. There's a lot of information here regarding permitting, restoration, and resources to help you complete a notification of lake or stream bed alteration. But you're going to start by clicking on the EPIMS online permitting portal. Next slide. Oh, this is our cannabis cultivation permitting website. A lot of good information here. There's 2 links here to the EPIMS online permitting portal. Next slide. And so you're going to need to register as a registered EPIMS user. Once you complete the registration, it'll go for a review from our clerical staff. It can take up to 72 hours to get approval, so just keep an eye on your email for that. Once you've received your registered EPIMS user, you can then start going through the application process in our online EPIMS system. So some regions around the state are still accepting paper notifications for this process. You're required to use EPIMS for self-certifications and general agreements. I'll get into that in a little bit. But starting on September 1st, 2020, all regions are going to require that notification be submitted through the EPIMS system. Next slide, please. So there's 3 pathways to compliance once you start the process in EPIMS: self-certification, the general agreement, and a standard agreement. I'm going to go through each of those next. The self-certification is a pathway meant for projects that are primarily indoor and on municipal water and sewer. The self-certification application is going to require you provide property location information, detailed project description, your water source, and project maps. The self-certification will then be submitted for review, and the department will determine if the project qualifies for a self-cert, in which case you'll receive written verification that an LSA agreement is not required, or it does not qualify, and then you'll have to go back and notify for an LSA agreement. There's no fee for the self-certification. Next slide, please. This is just an example of a notification in the system. If you answer a series of questions, the system will automatically kick you out of the self-cert if you're not eligible. So if you see this while you're going through, then it's best to just stop and go back and submit a standard notification or general agreement application. This isn't an error, it's just the way that the system looks. Next slide, please. So the general agreement is a pre-written permit that lies in our regulations. It is only for stream crossings or water diversions on non-fin fish streams or lakes. It's pre-written, it's exempt from CEQA. You're required to comply with the terms and conditions of the permit as it's written, and it has a term of 5 years. Next slide, please. So under the general agreement, because it's a pre-written permit, you're required to have all this information up front: a project location, description, a location of your water source, a biological resource assessment completed by a qualified professional, design plans by an engineer if applicable, and property diagrams. Fees are required and they vary by project cost. Next slide, please. So the most common pathway for compliance is going to be the standard agreement. This is the same permit pathway that all other projects in the state of California are required to go through for lake and stream bed alteration agreements. The permit is based on project and site-specific conditions. The applicant would work with CDFW to avoid or minimize project impacts. Again, just like every other pathway, you're going to be required to submit a detailed project description, including location, water source, with detailed maps and locations of your water sources. Next slide, please. So once you submit your notification for the standard agreement, CDFW is going to review that information. We might request additional detailed information if we determine that the notification is incomplete. We might request a site visit to go over the project on the ground. And if the department determines you need a permit, an LSA agreement, then we're required to comply with CEQA prior to issuing the final permit. Fees vary by cost, and this fee schedule is online for you to take a look at. Next slide, please. Some common delays to help yourself. Allow sufficient time. The department has a statutory timeline of 90 days to review and submit a draft agreement for your review. And then there's some other timelines that are associated with signing that permit and complying with CEQA. So plan for that time. Work with your regional office directly serving your project area so that you're you're submitting a complete notification and you're not overlooking something prior to the notification. And review your permitting options online before you begin so that you're starting down the correct pathway and not spinning your wheels in some pathway that's not appropriate for your project. This is a big one. Provide detailed information. Identify all activities associated with your project. This includes activities not taking place within a river, lake, or stream. So we want to know about your cultivation activities, but also how you're going to access the site, any culverts or stream crossings that you have on the way to the site, and then everything related to the entire project. Really, we can't have too much information. Next slide, please. Have access to your EPIMS account. If you have a consultant, make sure that you have access to it. And if your consultant is working on your behalf, be sure that your email is associated with that account so that you're also receiving the automatically generated information that comes from the system. submit the correct fees. EPIMS will help you by automatically calculating the correct fees, but definitely take a look at the fee schedule online so that you're submitting the correct fees. If you submit a notification with incorrect fees, it won't even be assigned for scientific review until we receive those fees. So it's just another delay. If you're subject to cannabis remediation fees, it's something to be sure that you submit with your project if you're cleaning up a previous site prior to booting up a new project. Next slide. So the department, again, is required to comply with CEQA if we're issuing a standard agreement. In most situations under cannabis, the county is going to be the CEQA lead agency, but the department can act as the lead agency. It's just a note there that's just another part of the puzzle. Next slide. Additionally to CEQA, the department implements the California Endangered Species Act. So if cultivation activities may result in the take of a threatened, endangered, or candidate species, then a separate CESA permit may be required. Next slide. Here's a list of a bunch of other code sections that apply to all sorts of things, including cannabis. I'm not going to go through them all, but it's just an illustration that there's a lot of regulation out there, and you want to just be in contact with the department and make sure that you're in compliance with all this stuff. Next slide. So there are enhanced fines and penalties for violations of Fish and Game Code sections in coordination with cannabis cultivation, substantial diversion, obstruction, or use, which is a 1602 violation. There's an additional 8,000 to 10,000 per violation per day fine, and for water pollution violations, you're looking at $20,000 to $40,000 per day. So get in compliance. Next slide. After permitting, compliance includes keeping a copy of your lake and streamlet alteration agreement or letter stating that one is not required on site at all times. CDFW might request a compliant site inspection of the site, and new notification may be required if your activities change substantially. So again, I think that comes back to being in touch with your regional permitting folks to make sure that if your project's changing, if you need a new notification or not. Always ensure that the work is being completed in accordance with your permit, and contact the department if anything isn't clear. If you've got folks working on your behalf on site under that permit, be sure that they're aware of the requirements of that permit, because compliance is the responsibility of the permittee. And generally keep a clean site. That's something we tell everyone when we're out and about. Next slide. We want to avoid nasty stuff like this. This is just some extreme illustrations of trash and deleterious materials placed within or adjacent to some streams. So next slide, please. So we want you to start your permit process and work closely with your regional staff. Not only do we want to help you protect fish and wildlife resources, but we want to help you protect your investment as well. Next slide. These are contact information for each regional office. We'll pause here for a second if you want to take a screenshot or whatever you need. Work closely with these folks, please. We want to help get you into compliance as well. And that's all I have today. Thanks.
Thank you. My name is Mike Rubens with the State Water Resources Control Board Division of Water Quality. Together with my colleague Jonathan Pham with the Division of Water Rights, we will be presenting on how the State Water Board fits in with the cannabis cultivation permitting and compliance process. Just to give a roadmap of the presentation today, we'll start out with an overview of the Water Board structure, and then I'll touch on the different documents that guide our actions, the Cannabis Cultivation Policy and the Cannabis Cultivation General Order, and how these affect you in your permitting process. Then I will hand it off to Water Rights to discuss those requirements, as well as the application portal and some other additional resources. So as I mentioned, I'm with the State Water Board Division of Water Quality, and my colleague is with the Division of Water Rights. These are both based in our headquarters in Sacramento, along with our Office of Enforcement. We also have 9 regional water quality control boards who are stationed throughout the state. Some of these regional water boards have joined forces to create regional cannabis units, for example, the South Coast Cannabis Unit or the Eastern California Cannabis Unit. These regional units are available to help with outreach and messaging. These are the entities that generally issue your cannabis cultivation general order permits or notice of applicability. Staff at the regions also determine compliance and sometimes initiate enforcement, but they are available to help with technical assistance as well. The primary components that the State Water Board cannabis regulatory structure works under involves a few documents or programs: the cannabis policy, the cannabis cultivation general order, and the cannabis small irrigation use registration, or SIUR. The cannabis policy describes the overall structure of the water boards and how we fit in with the other agencies that regulate cannabis cultivation. It also establishes water quality and in-stream flow requirements and other requirements that are conditioned in your permit. This policy may be updated as necessary and has been updated once before. This visual shows how the State Water Board Cannabis Cultivation Program fits in with CalCannabis's cultivation licensing. On the left side of this visual, we have the General Order Waste Discharge Regulatory Program, which is carried out by the State Water Board Division of Water Quality and the Regional Water Quality Control Boards. On the right side, we have the Small Irrigation Use Registration Program, which is implemented by the State Water Board Division of Water Rights. These are both required, or you need to check with the State Water Board to get a document to take to CalCannabis to prove that you have either obtained the permit coverage that you need or have proof that you do not need the permits that we offer before you can get your cultivation license with CalCannabis. Getting into the actual document itself of the cannabis policy, the main part of the document stresses how the Water Board's program fits in with the other programs that regulate cannabis cultivation, and it explains how our policy is enforced. Much of the meat and potatoes of this policy is included in Attachment A. So the requirements for these permits and prohibitions for activities related to cannabis cultivation, as well as requirements for water diversion. Near the end of the Attachment A in Section 5 and 6 are some useful documents and guidance that you will find helpful as you are applying. I just want to re-emphasize on this slide why we are carrying out these programs and requiring coverage for cannabis cultivation. We want to prevent activities that can lead to damage to fish and wildlife and the natural habitat. So these activities include illegal grading or illegal water diversions, improper storage of fuels, pesticides, or fertilizer, and things like clear cutting of trees that we want to prevent. The Cannabis Cultivation General Order is the statewide program to protect water quality, and the order number is WQ 2019-0001 DWQ, and this number was updated when the policy was updated. As I mentioned, this is implemented by the State Water Board Division of Water Quality, along with the regional water boards, and this is required coverage for the Cdfa's CalCannabis license. You may hear this referred to as the Water Quality Permit or a Water Quality Protection Program by other agencies. If you hear that, they are likely referring to the Cannabis Cultivation General Order Notice of Applicability that you will receive after you apply. The structure of the Cannabis Cultivation General Order coverage is broken out into two different facets, the first of which, discussed on this slide, the disturbed area size. Tier 1 enrollees will have disturbed area equal to or greater than 2,000 square feet, but less than 1 acre. If your disturbed area is greater than or equal to 1 acre, you will be enrolled under the Tier 2 category. And this disturbed area includes not only your cannabis cultivation area, but other areas where activities associated with developing or modifying land for cannabis cultivation related activities occur. And this can include areas where soil amendments or fertilizer are stored, areas where plant growth has been modified, or in some cases, your access roads. And this added because roads that are constructed and maintained consistent with the roads handbook are not considered disturbed area for the purposes of your general order enrollment for cannabis cultivation. And again, I want to stress that your disturbed area is always greater than your cultivation area. The other facet of general order coverage is the risk determination. For low risk, we have sites that have disturbed area located on a slope less than 30%, and your disturbed area is located outside of the riparian setbacks. I'll have more information about the setback requirements in a moment. The moderate risk category is for sites with a disturbed area slope greater than 30%, but less than 50%. You will still need to comply with the riparian setback requirements to be in the moderate risk category. The high risk category is for sites that do not comply with the riparian setback requirements. These riparian setback requirements are similar to the watercourse classes that were mentioned by Fish and Wildlife with the perennial, intermittent, and ephemeral watercourses. Depending on which watercourse class, this riparian buffer is more restrictive. So for perennial watercourses, the setback is 150 feet. And moving down through this table, we have smaller buffer requirements for man-made water bodies. Please refer to the watercourse definitions in the Cannabis Policy Attachment A and work with a qualified professional or seek technical assistance from your regional water board if you have questions about this. We also offer a couple different indoor conditional waivers for sites that qualify. So the indoor conditional waiver is for sites with a permanent roof or permanent relatively impermeable floor. So notably, this does not include hoop houses with a dirt floor or other similar structures. In addition to your activities taking place indoors, you will also need to discharge your wastewater to a sewer that accepts cannabis cultivation wastewater, or have your wastewater stored and hauled away. You will also need to comply with the requirements in Cannabis Policy Attachment A and obtain a valid water right to be enrolled under this waiver. There is also an option for an outdoor conditional waiver, and this is for small commercial cultivation sites that total less than 2,000 square feet of disturbed area. The cultivation area must be contiguous or located all in one area. There is a 20% slope limit that you cannot exceed to comply with this waiver condition. And again, you'll need to comply with the requirements in Attachment A and get a valid water right. The fee structure for the cannabis cultivation general order ranges from a fee of $600 for the Tier 1 low risk category to an application fee of $8,000 for the Tier 2 high risk category. Generally speaking, higher tier and higher risk categories are required to pay higher fees because of greater threat to water quality and greater oversight requirements. And conversely, the conditional exemptions are a pathway for lower fees for enrollment with us. After you apply, please refer to your notice of receipt for the Cannabis Cultivation General Order for more information about fee payment and other requirements based on your tier and risk category. The full fee schedule is available at our website, waterboards.ca.gov/cannabis. Following the same logic as the fee structure, there are different technical report requirements based on your tier and risk category. All Tier 1 and Tier 2 enrollees will need to submit a site management plan when you apply. Sites that are enrolled under the moderate risk category will also need to submit a site erosion and sediment control plan. High-risk enrollees will need to submit a disturbed area stabilization plan. If you are a Tier 2 enrollee with a cultivation area that exceeds 1 acre, note that this is different than the disturbed area. You will need to submit a nitrogen management plan. Instructions for how to submit these will be included in your notice of receipt. Tier 1 and Tier 2 enrollees are also required to submit an annual monitoring report. And if you have received your notice of applicability, you will need to report your annual monitoring, even if you did not have plants in the ground yet. And this is because there are other activities besides growing that may have impacts on water quality. This annual monitoring report is submitted through the same website as your application, and we will have more information on that application website in a moment. The annual report is due on March 1st, following the calendar year that monitoring is required for. The annual monitoring report will verify your compliance with the general order and ask you these types of questions, such as your facility status, site maintenance status, or stormwater runoff monitoring. Please be aware of what your monitoring requirements are when you enroll, so you can collect this data. The monitoring report will ask you the questions that you need to answer based on your enrollment, so it is pretty helpful in that way. For people who have been enrolled and wish to terminate their enrollment, you will need to submit a cannabis order termination request form using that same program portal that I mentioned a moment ago. Tier 1 and Tier 2 dischargers who wish to terminate their enrollment will also need to submit a final monitoring report, and this is an option within the annual monitoring report survey. This slide shows some of the helpful resources that are included in our regulatory documents. And for example, section or attachment B has guidance on the monitoring and reporting program. Attachment C of the general order has guidance for the notice of termination, and attachment D has other technical report guidance to assist you with submitting your reports. And with that, I will pass it off to my colleague, Jonathan Pham with Water Rights.
Good morning. My name is Jonathan Pham. I'm an environmental scientist with the Cannabis Registration Unit in the Division of Water Rights. I'm presenting the water rights portion of the State Water Board's presentation. So your first question may be, do you need a water right? Here we have a diagram answering that question based on your water source. Moving from the left to the right of this diagram, if you're diverting surface water, you will either need a small irrigation use registration, or an SIUR, or another valid water right. The SIUR program was made for commercial cannabis growers to rapidly obtain water rights to store water. Other valid water rights typically refers to senior appropriative water rights or pre-1914 rights, both of which must have listed irrigation as a beneficial use, in addition to allowing for long-term storage. On the right side of the diagram, we have water sources exempt from a water right. The first being a fully contained spring. These are springs that do not leave your property. These are quite rare, and if you do believe that you have one, reach out to us and we can provide details on the exemption process. Other exempt sources include groundwater wells, water purveyors such as like irrigation districts, rainwater catchment. Regardless of your water source, you'll still need to submit some type of water source documentation to Cal Cannabis. This will either be in the form of a water right or exemption documents that you obtain through the Water Board's application portal. Next slide, please. So what type of right do you need? Remember, the SIUR is for commercial cannabis cultivation. So for sale, trade, and barter, you'll need the SIUR. Other water rights can be used if they have irrigation as a use and enough storage to last you through the forbearance period. I'll touch upon the forbearance period in later slides. As for personal use, if you have 6 plants or less, you can use the Small Domestic Use Registration, also known as an SDU. This also covers your domestic residential water uses. Next slide, please. So there are some conditions. You must comply with the general conditions, CDFW conditions, as well as the conditions in the cannabis policy. This allows you up to 6.6 acre-feet per year of diversion and a maximum instantaneous diversion rate of 10 gallons per minute. We find that most farms are requesting diversions much less than the 6.6 acre-feet. Next slide, please. There's a $750 registration fee and a recurring annual fee of that same amount. This permits diversions to storage during the wet season. So this is November 1st through March 31st. So on the opposite, this imposes a forbearance period in which no diversions are allowed from April 1st to October 31st. And that can potentially last longer depending on flow rate data. Next slide, please. So during the diversion season, you can check to see if a diversion is allowed given your area. So from the main cannabis water rights page, there's a link to the online cannabis compliance gauge mapping tool. This mapping tool can be used during the diversion season to determine if there are sufficient flows to divert water for cannabis. The main justification of the forbearance period is to divert during times of high flow and store during times of low flow, which also overlaps with the grow season. Next slide. There are limitations, however. No water rights will be issued for diversions on fully appropriated streams in which there is no water to allocate to new water rights holders. Wild and scenic rivers, and that could be protected at the federal or state level, and CDFW in-stream flow study areas. Next slide. So here we have on-stream reservoirs. Last year, there were updates to the policy to allow for on-stream reservoirs. Previously, they were prohibited. On-stream reservoirs are ponds that collect channelized surface flows. They are allowed if they are pre-existing prior to October 1st, 2016. If they were in the AB 2121 North Coast Policy Area, the reservoir must exist prior to July 19, 2006 on a Class 1 or 2 stream, or October 1st, 2016 on a Class 3 stream. Next slide, please. Additionally, the State Water Board and CDFW will have to come to a determination that decommissioning the pond would be more environmentally detrimental than continued diversion into the reservoir. There are additional fees for on-stream reservoirs as opposed to the normal SIUR. So there's a $4,000 fee, bringing the initial fee to $4,750 for the on-stream reservoir SIUR, and the annual fees will be increased by $250, bringing the annual recurring fee to $1,000. Next slide. Now I'll provide an overview of the online application portal and process. Next slide. By following this link on the page, you can reach the portal login and register page. Here you can register for a new account using a valid email address and apply for your water board's permits. This includes the Division of Water Quality's general order enrollment, as well as the Division of Water Rights SIUR application. Next. Here is a flowchart describing the process. First, the applicant creates an account and answers water quality and water rights questions. Once the applicant submits the application, they'll receive a notice of receipt, one for your Division of Water Quality permit and one for your Division of Water Rights permit. They will have site-specific fee amounts and or exemptions. Once a payment is received, staff reviews applications and contacts the applicant if additional materials or clarifications are needed. Once all application deficiencies are resolved, applicant receives the NOA for the Division of Water Quality and or their SIUR certificate from the Division of Water Rights. It is important to note that although both the water quality and water rights applications are on the same portal, they are reviewed by different staff. Next, please. Here, for some spatial reference, we have a distribution of our permits. On the left side, we have water quality, and the right side, we have water rights. You'll see in water quality, the green dots are actually for outdoor grows, while yellow are for indoor grows. And they are distributed throughout the state with a concentration of outdoor grows in the North Coast. For water rights, you'll see that this mostly concentrated in the North Coast because that is where the majority of surface water diversions occur for cannabis. As we move closer to Southern California, they are more concentrated on wells. Next, please. Our permits are not contingent on any other agency, so you can actually apply today. In some cases, if you're using exempt sources, you can get your exemption documents in 10 to 20 minutes. Additionally, here are some of our social media contacts. We have an Instagram, Facebook, and Twitter. Next. And here are some of our contact information, the first being water rights. So if you have any questions about the SIUR process, feel free to reach out to the Cannabis Registration Unit. And on the bottom, we have Divisional Water Quality contact information. So if you have any questions about getting your notice of applicability or just a general order in general, feel free to reach out to those numbers. So I'll leave it here for just a quick second if you need to take pictures of these contacts. Next, please. And here are some important links. So the first is the online portal. The next is the Handbook for Forest, Ranch, and Rural Roads. Remember, if your roads are designed and maintained in a fashion that is compliant or consistent with the Rural Roads Handbook, they are not considered disturbed areas. We have some more information on the general order with attachment A and overall general information. And with that, I conclude my water rights presentation. Thank you for your time.
Yes, this is Lila Fedler, and I'm with the California Franchise Tax Board, and we're going to talk about doing business in California in the cannabis industry. We're here today because we do get a lot of calls with individuals that are wanting to start a business, wanting to know how do you register with the Franchise Tax Board. As you've been hearing from these other agencies, you do have to register with them. But when it comes to the Franchise Tax Board, we get our information directly from the source. So if you've registered or gotten a license with your local city or county, we're going to get that directly from them. If you've created a corporation or a limited liability company, we will get that information directly from the Secretary of State. Next slide, please. So when it comes to taxation in the cannabis industry, it can be a complicated issue. Most importantly is the fact that at the federal level, IRC Code Section 280E is a provision that will highly limit the amount of deductions that a business entity that is conducting business in the cannabis will limit your deductions. Until January 1st, 2020, there was a disparity between California law when it came to corporations and those that were taxed under the personal income tax. As of January 1st, IRC 280E no longer applies for California purposes when you're taxed under the personal income tax provisions. There is a limited range of time in which this law is effective. It does go until January 1st, 2025. That's usually referred to as a sunset. The state legislatures usually, when they make a law change, will do a limited application just to make sure that it's working the way they intended. So 280E no longer applies for individual purposes, but the state legislatures did require the Franchise Tax Board to gather information as to the effects of this law change. So if you are taxed under the personal income tax provisions, or if you receive flow-through deductions as a corporation from an entity that's taxed as under the personal income tax provisions, you will find this next year a new form that you're going to need to fill out to advise as to what you are claiming for the cannabis industry. This will apply to other areas because of a other provision that requires all business new deductions and credits to be accounted for and reported to the legislature. Next slide. So as I was saying, businesses are, the taxation can be very complicated. The first thing you really need to do is decide which way in which you want to conduct business. You can conduct business in the state of California by various business structures. You can be a sole proprietorship, you can be a partnership, you can be a limited partnership, You can be a corporation. You can even be a limited liability company. Each one of those types of business have different sets of rules in which they are to be applied, how they are taxed, when the tax is to be paid, and even sometimes the way in which deductions are allowed. That is the first step that you're going to want to take because it's going to determine who the applicant is. What you've been hearing with these other state agencies is there's an application fee. I like to give the analogy of a legal entity like a corporation or an LLC as giving birth to like an 18-year-old child. Because when you apply, the applicant, when you're a corporation or an LLC, is that 18-year-old child. It's not you. When you're a sole proprietor, you are the business. There is no separation. So you're the applicant when it comes to sole proprietorships and partnerships that that can apply. You can do business on either a for-profit or not-for-profit basis. It all depends upon how you want to structure the entity at the time if you're forming it with the Secretary of State, for-profit or not-for-profit. Again, there are different rules depending upon how you've structured it. Just so you know, California does not grant tax-exempt status to anybody that is conducting business in the cannabis industry. And that's because of our tie to the federal code sections and the fact that the federal is still considering this to be an illegal activity is subject to great limitations. Next slide, please. We do provide our publication 1123 that kind of gives you a really simple terms explanation as to the different forms in which you can conduct business and the requirements to file and pay taxes. For example, a sole proprietorship, you're an individual, you're just going to report the income on Schedule C if you're a business, on Schedule F if you're a farmer, and you'll just pay the incremental rate of tax for an individual on any profit that you have. If you form a corporation or a limited liability company, again, you've formed a separate legal existence. That legal existence has its own filing requirement. California will always require a corporation to file a tax return. It's going to be a Form 100 or a 100S if you've chosen to be taxed under Subchapter S. And an LLC will always have a filing requirement too. At the federal level, a single member LLC may be disregarded, but under California law, a single member LLC still has the requirement to file a tax return. That's the Form 568. It will have an annual tax of $800. And if you have sales of over $250,000, you'll have an LLC fee. That fee is graduated, meaning that between 250 and less than 500,000, the fee is 900. Over 500,000, the fee jumps to 2,500. At $1 million, it's 6,000. At 5 million, it's $11,790. When you file and pay the tax will also depend upon your legal structure. Limited liability companies, often referred to as LLCs, their annual tax, the $800, has to be paid within the 15th day of the 4th month of the beginning of your year. Generally, limited liability companies have to be on a calendar year. So every year other than the first year, that's going to normally be April 15th, as that's the 15th day of the 4th month of your year. When you form an entity, the year of the formation, your year begins upon formation. So here we're sitting in July. If you were to go out and form an entity today, July, August, September, October 15th is when the $800 would be due for an entity formed today as an LLC. Now, LLCs can make an election to be taxed as a corporation. That's a federal election form, or they can elect to be taxed as a Subchapter S. If they make those elections, then they file corporate tax returns with the state of California, the Form 100 or 100S, and they will pay the income tax based upon their income rate for that type of entity. California does waive the minimum tax the first year as a corporation, which means you don't pay a tax the first year unless you actually make a profit. Corporations pay, a C corporation pays an income rate of 8.84%. So don't make a profit the first year, no income tax. Every year after that, if 8.84 of your profit is less than 800, you'll round up to 800, and that's the tax you'll owe. An S corporation pays an income rate of 1.5. Again, just like a C corp, no profit the first year, no tax for an S corporation. Every year after that, you will look at how much net income you have, multiply it times 1.5. If that answer is greater than 800, that's the tax you'll pay. If it's less than 800, you'll round up to 800. If you're thinking about starting in this industry this year, I might tell you that it might be a good time to think about waiting. It was a law that was recently signed by the governor that will exempt limited liability companies from the annual tax the first year, but that law goes into effect in 2021, which means if you form an LLC this year, you will have an $800 annual tax, whether you do business or not, whether you make a profit or not. Wait till next year, January 2021, the first year annual tax will get waived, but not this year. If you did form an entity and it looks like you're not going to be doing business, you can close it down within 12 months of the formation of the entity with the Secretary of State and not owe a tax if you do no business in that first 12 months. If it's over 12 months and you formed a legal entity and you want to close it down, you can proceed to do that. There was a law that went into effect on January 1st, 2019 that allows the Franchise Tax Board to waive qualified tax penalties and interest for those entities that have been in existence for more than 12 months, that have never done business or stopped doing business and have no assets. That is what we call an administrative, voluntary administrative dissolution. Not-for-profits can qualify for the voluntary administrative dissolution. And if you're thinking that you might qualify to get qualified tax penalties and interest waived, you would fill out the form 3502. If you're a for-profit corporation, the form you want to consider filing is the 3715. And if you're a limited liability company, an LLC, the form you need to review is the 3716. Next slide, please. We do have resources available at the Franchise Tax Board's website, ftb.ca.gov, specifically designed for those individuals doing business in the cannabis industry. The page does break down the different types of businesses that you can be, the sole proprietor, the partnerships, the corporations, and information there. We have a lot of questions because a lot of individuals that are in business in the cannabis industries are having issues getting bank accounts. And how do I pay my taxes if I can't get a bank account? If you do need to pay by cash, we do have an exemption application that allows you to fill out and apply to pay by cash in one of our district offices. Our district offices are currently closed except by appointment only. You can go to the Franchise Tax Board's website, and on our website you can Google the information to excuse me, to apply for an appointment at one of our district offices and make arrangements for paying in cash. The other thing that we get a lot of calls for is the MyFTB, and individuals that have created a legal entity like a corporation or an LLC, they're immediately wanting to create a MyFTB account. The Franchise Tax Board's MyFTB account actually gives you access to the records. And as a business owner, you can apply and get access, but you have to do it after you file your first return. The way we do our validation process is the first one is when you're registering with the MyFTB as a business representative, you'll have to have a previously filed tax return in hand. That's the first way we validate that you are legally entitled to the information we will share with you. We do require a second form of validation, which requires us to send a PIN through the mail. And we will only send that PIN to an address that we already have on record, which will come from that previously filed return, your most recently filed one. So if you're filing your 2019 return, that's the address of record that the Franchise Tax Board will use. If you create a MyFTB account, you do have to wait about 5 months after you file your 2019 return to allow us time to process it so that we can validate against that information. If you've filed previous returns for 18 or 17, you can go ahead and register for the MyFTB. A PIN comes in the mail within 5 to 7 business days is when you should expect to get the PIN. When you get that, it's very important to come to the Franchise Tax Board's website and finish your registration. That PIN is only good for a limited period of time. So when you get it in the mail, come back, finalize your registration, then you will not need that PIN in the future. You'll have your login, you'll have your password, you'll have the questions that we have to answer, ask for you to answer. And that will give you 24/7 access to your tax records. If you've ever needed to know, did I make that payment? Have I filed that return? Or more importantly, just communicating with the department. Getting through the Franchise Tax Board's phone lines can be a very difficult task to achieve. This is a state of over 40 million individuals and business entities. Unlike the Employment Development Department that deals with businesses that have employees, and unlike the California Department of Tax and Fee that deals with your resale license and your other cannabis licensing, all business entities, whether they've got a need to register with Cdfa or the Employment Development Department, do contact the Franchise Tax Board. So getting through to our phone lines can sometimes be very daunting task. When you've created a MyFTB account, one of the things that you can do during our business hours is to log into your account and then open what's called a secure chat. The secure chat's like an instant messaging with one of our staffers. The phones, only one person can speak to, we can only answer one call at a time when it comes to a phone line, but with a secure chat, multiple communications can transpire. So that actually gives you a better process of getting through and communicating with us. Also, we have something called send a message. I refer to it as bypassing the U.S. Postal Service, because if you upload correspondence to the Franchise Tax Board's MyFTB account, it immediately goes onto your account. It expedites the correspondence process, and you have confirmation that the department received your correspondence instantly. You can immediately see the documents that you've submitted to the Franchise Tax Board, plus any communications that we've sent out to you. Next slide. So another resource the Franchise Tax Board does offer is the Small Business Liaison Line. That phone number is 916-845-4669. This is an informational line. If you just have questions, you're not sure how to fill out the forms, do I have to file the form? What's the process? Those are questions that we can answer at the Small Business Liaison Line. This line does not have access to accounts, so we cannot confirm whether or not you've made a payment. Have you filed that return? We can answer the general questions as to when the tax return is due, when would you normally have to file a tax return, but to prevent the people that normally would have to speak to the 800 number, keeping the line clear for those business owners that just have questions. This is just an informational line. With that, I will turn over the presentation to the next presenter.
Good morning. Hi there. My name is Shalini Hunter, and I'm a civil rights consultant with the Department of Fair Employment and Housing. And I'm pleased to be here this morning with everyone, though I do wish we were in person. I'm going to share a little bit about our department. Most folks don't know what Department of Fair Employment and Housing is, so we're going to jump right into the mission, which it's really, we are responsible for protecting the people of California from unlawful discrimination. And this covers employment, housing, public accommodations. It covers hate violence, as well as human trafficking. Next slide. Next slide. We have a number of really significant responsibilities. We engage in public outreach and provide training, such as this morning's. We investigate discrimination complaints in cases of systemic discrimination. We facilitate mediation and resolution of disputes involving civil rights. And we also enforce the laws by prosecuting violations in civil court. So we really run the gamut from prevention to litigation and everything in between. Next slide. For the purposes of today's conversation, we are going to focus on employment. So how do we accomplish our responsibilities as an agency? We really rely on the law. So we are relying on things like the Fair Employment and Housing Act, the RALPH Act, which covers hate crimes. We rely on the UNRU Act, which covers businesses, the Disabled Persons Act, and we rely on human trafficking laws. So these laws protect individuals from discrimination that's based on protected classes. So that's the list you have in front of you right now. We all fit under at least one protected class, which is gender. Many of us will fit under two protected classes, which is hopefully we all get to the age 40 and over. And then many of us fall into more than one of these other categories: race, familial, sexual orientation, gender identity, marital status, and so on. Next slide. So who must comply with the laws? Public employers, private employers, labor organizations, and employment agencies, essentially everyone. So we're going to discuss a little bit about the employer requirements, a little bit about prevention, and then the complaint process should discrimination actually occur. So as an employer, there are certain required notices that must be shared with employees. These include information on employment discrimination, family leave, sexual harassment, transgender rights, and rights of pregnant employees. Next slide. So these two posters, the first is employment discrimination, and this reviews the protected classes and unlawful behavior. This is really critical for employees to know of their protections and who to contact if they feel that they have or are experiencing discrimination. The family leave poster reviews the employee's rights to family care or medical leave for the birth, adoption, foster care placement of a child, or for their own serious health condition or that of a child, parent, or spouse. California law also prohibits employers from denying or interfering with requests for pregnancy disability leave. Really critical information for both employers and employees to know. Next slide. The sexual harassment fact sheet defines sexual harassment, the different types and behaviors, and additionally, this past year, legislators have passed a new law requiring our department to make online training courses available on the prevention of sexual harassment as well as abusive conduct in the workplace. The employer version can be found on our website, and the supervisor version will be released shortly. All of the trainings are in multiple languages as well, so this is going to be really helpful for your organizations to check out. The transgender poster reviews the definition and the best practices for employers to utilize to make sure transgender employees' rights are secured. Dead naming or using the name used prior to transition, using the wrong pronoun intentionally, or demanding an employee use a particular bathroom that doesn't correspond to their gender identity is harassment and unlawful. Next slide. The final required poster provides information on employers' obligations to a pregnant employee. This, again, is really complicated stuff and critical for employees and employers to know what's available to them in terms of protected leave. DFEH is also working right now on a phone app that employees can use to tap into, employees or employers can tap into for the different protections related to becoming a parent. Next slide. Setting aside the requirements for a minute, I want to lift up diversity, inclusion, and equity. It goes a long way in preventing discrimination. So it's really helpful if employers generally, and in particular this industry, recognize systemic racism and the damaging and long-term impact that federal and state cannabis enforcement policies have had on Black and Brown communities. We all know a little bit about the war on drugs. Recognizing this systemic racism will allow for employers to take a holistic approach to reverse racism's historic and damaging effects. So these are things like, you know, any substantive lasting change must be institutionalized and embedded within your business plan. Things like diversity, equity, and inclusion can be achieved through primary focus informing personnel requirement protocols in job postings, outreach plans for employment and apprenticeship programs, anti-racism training for vendors and employees, in addition to having specialized trainings for employees responsible for the hiring, screening, interview panels, and supervision. Really demonstrating leadership in this endeavor can also be incentivized by commensurate salary and promotional opportunities. And such efforts will provide immediate measurable steps needed to reduce discrimination for, excuse me, historically racialized populations within this business. And really beyond the heightened moment of today's pandemic and protests, we've got a lot going on, and this really will go a long way towards keeping businesses out of litigation and really focusing on that equity piece. Next slide. So hopefully the laws are followed, but lots of times discrimination does occur, and we have a process for that. We do have this complaint process with DFEH. It is described more fully on our website, but essentially it's made up of 7 different elements, starting with intake and running through civil litigation. Next slide. Generally, when somebody files a discrimination complaint, what DFEH will evaluate the facts and will decide whether to accept the case for investigation. If it is accepted, if it is accepted, we independently investigate the facts and the legal issues. This will involve reviewing respondents' responses to complaints and other information and evidence that the complainant and the respondent submit. Among other things, DFEH will attempt to resolve the dispute in appropriate cases. So hopefully we can get through mediation before it actually goes to litigation. But there's always that ability to take that final legal action if need be. Next slide. So remedies for unlawful discrimination cover a number of different things. Reimbursement for actual losses and compensation for emotional distress. Hiring and reinstatement is probably the most common for employment discrimination. Back pay or promotions. Training and policy changes is the other probably most common remedy. So employers are required to take training and make some policy changes to make sure that that doesn't happen again. Usually that's tied to also monitoring by DFEH and ongoing reporting. There's also civil penalties, punitive damages, and attorney's fees and costs to the department if it prevails. Next slide. This is our contact information. We have not only can answer questions around the complaint process, but we also have an outreach team. So if you would like us to provide specific training on any of our employment discrimination or any other subject that you might have an interest in, please feel free to reach out to us, and we're happy to do that. Again, we are the civil rights organization for the state of California. We provide these required posters for folks to have and share with their employees, really as a preventative measure so that you can avoid the litigation process. That is all for me. Thank you.
Good morning, everybody. My name is James Wong, and I am with the EDD. And today I'm going to talk to you a little bit about our department and what we do and some of the services that we provide, but mainly the importance of reporting your workers and your employees to our department. So I know when most people think of EDD, they think of unemployment insurance. And that is one part of our department, but the EDD is also the state agency that collects part of your payroll taxes. So some of you may not be familiar with payroll taxes if you've never owned your own business, but we've all seen them before. So if you ever look at your paycheck and you see all those taxes are being taken out, those are your payroll taxes. So now that once you guys have started your business and you start hiring people to work for you, now it's going to be your turn to take care of those taxes and send them into our department. Now, if you have questions about anything I covered today or questions in the future, take a look at our website, which has a wealth of information on there about payroll taxes and also about unemployment insurance and disability insurance. Now, you can also call our toll-free number to our Taxpayer Assistance Center, which is right there on the screen. And again, it's a toll-free number. And if you have questions concerning payroll taxes. Now, we also have free seminars that we do, so you can come and learn all about payroll taxes. Now, and I'll talk a little bit about more of those later on, but you can also find all our seminars on our website as shown on the screen. So next slide. So today, I'm going to talk briefly about, again, the importance of reporting your workers to the EDD. Okay, so whether you're going to hire employees to work for you, or you're going to use what we call an independent contractor, it's very important to know when to report these workers to EDD and pay the necessary taxes. So some of you may have heard about the new law that went into effect this year regarding independent contractors, and I'll also talk about that in a minute. So this is important because if you use an independent contractor and then it turns out they're really an employee, you could owe taxes to our department. And I'll talk a little bit about that later on as well. And we'll also talk about some of the resources that are available to help you. Okay, next slide. So let's talk a little bit about numbers. So this chart illustrates what your cost could be to EDD. So on the left-hand side, the very first column, that shows what your state payroll taxes are. So you have your unemployment insurance, your employment training tax, state disability insurance, and personal income tax. Now, some of you guys are probably familiar with these. Again, if you have payroll, but these are the 4 state taxes that are sent to our department. So if you look on the column on the right, where it says employer correctly classifies worker as employee. So let's say you hire one person and you pay him $20,000 for the year. You pay him $20,000. And so if you look at the column on the right, this is what you would owe to EDD. So you would owe $238 for the unemployment insurance tax, $7 for the employment training tax. You don't pay state disability and personal income tax because the employee pays that. So what you would owe to our department is a total of $245 for this one person that you paid $20,000 to for the year. Now, if you treat this person as an independent contractor, and then we come in and say it's really an employee, you're going to owe the taxes that are shown there on the middle column. So the $238, the $7, the $200, the $1,200, for a total of $1,645. So for this one person that was an independent contractor, but we say he's really an employee. So as you can see, that's quite a difference. That's quite a difference as far as how much you would owe. So as you can see, it can be very costly, very expensive if you treat somebody as an independent contractor, and then it turns out they're really an employee. Okay, so let's go on to the next slide. Now, there are a lot of misconceptions about independent contractors. And some of you may have heard about some of these in the past. So we like to get these out of the way first before we talk about the independent contractors. And this handout that shows you on the bottom, this DE 573M, the independent contractor misconception. This is available on our website. You can download it. And it talks all about what the common misconceptions are about independent contractors. And some of you may have heard of some of these. One of the most common things we always hear is, well, I have a hair salon, and I know all the hair salons treat their workers as independent contractors. So I'm going to do the same thing because it must be okay to do so. Okay, so remember, that's not always the case, because again, there are rules and guidelines that you have to follow to see whether the person's independent or not. You can't just hire somebody and say they're going to be an independent contractor because that's what somebody else does. Another common misconception we hear is, well, the worker, he's not a regular employee. He only worked for me for a few days, for a week, on a temporary basis. Okay, just remember, even though somebody works for you on a temporary basis, that doesn't mean they're an independent contractor, because again, you have to go by the rules to see whether they're employees or not. So again, take a look at this handout, the DE 573M, and talks about some of the common misconceptions. Okay, let's go on to the next slide. So just remember, whenever you hire people to work for you and you pay them for their services, they're subject employees and they have to be on the payroll. So this could include all types of workers and volunteers too. Next slide. Again, especially if you pay them. Now remember, if you're a corporation, and Lila talked a little bit about this earlier, if you decide to have a corporation, corporate officers by law are employees. Okay, so this is another common mistake people make. So again, whether you hire a manager, maybe customer service people, cultivators, harvesters, they're all employees, again, if you control what they're doing. Next slide. Now, I mentioned earlier about the new law that went into effect, and this has been in the news a lot lately. And it's very important that you're familiar with this law, especially if you're going to use independent contractors in your business, because it changes everything. So someone who you thought might be an independent contractor before might not be now. And this new law is called Assembly Bill 5, or AB 5, and it came about. Again, it goes into effect. It went into effect January 1st this year. It came into effect because of this company called Dynamics, and it went all the way up to the Superior Court. So whenever you hear people talk about the Dynamics case or Dynamics, this is what they're talking about. So as a result of this case, that the Supreme Court came out with a new set of rules to determine whether somebody's an independent contractor or not. Now, in the past, we would look at things like, did you control the worker and tell them what to do? You know, did you set their hours? Did you supervise them? Did you determine the rate of pay? These are all things we would look at to determine whether you control the person. Now, with this new test, you have to use to see if the worker is really an independent contractor or not. It's called the ABC test. Okay, they call it the ABC test. Now, there's a lot of information online and on the EDD website about the new law, again, which is called AB5. Or you can just Google AB5 or ABC test, and you'll get all kinds of information about this. Now, so in that case, they came out with this new test to determine whether you're an independent contractor or not. And it's basically a shorter test now, where you have to meet 3 criteria, 3 conditions, and all 3 of those conditions have to be met in order for the person to be an independent contractor. Now, there are some exceptions to this test, which means there are certain types of workers that are not subject to the ABC test. So in which case, you go back and use the old method to determine if the person's an independent contractor or not. So we're not entirely done with the old method of determining if somebody's an independent contractor. But again, if there's no exception, then you go with the ABC test. And those exceptions, that's all on our website and online as well. Okay, next slide. Now, there are a lot of resources to help you. So even though after going through all this, if you're still not sure, I encourage you to take a look at our website, which has a lot of information about payroll taxes, using independent contractors, and of course the new law, AB 5. And also there are a lot of resources to help you. We also have, as I mentioned earlier, free seminars for you to come and learn all about payroll taxes and what your responsibilities are to the EDD. Right now, we have these classes set up as webinars, but once this pandemic is over, we will have in-person classes again. So come to one of our seminars. We have basic seminars that talk about the taxes. We have seminars that just talk about employee independent contractor. So we have a couple of different classes that are available for you. So we do these classes regularly throughout all of the states. So just go to our website and you can find one near you. So even though you might not be ready to go to a seminar today, but maybe 6 months from now or a year from now, you decide I want to learn about payroll taxes, go to our website and see when we're going to have one near you. And as I mentioned, they're all free. Now, another resource I want to mention is the first one on this chart. I'm sorry, the second one, which is the Determination of Employment Work Status, the DE 1870, which is also available on the EDD website. So what this is a questionnaire. It's a questionnaire, you fill it out, you send it in to us, we'll send you something in writing telling you whether the person's an independent contractor or not. So we'll give you a determination based on the information that you provide to us. So this would be a great tool for you to use if you're not sure or you want to protect yourself, because if we do come in and do an audit or an investigation of your business and we say, hey, this guy's an employee, you can say, well, wait a minute, you sent this to me saying he's not. So it would protect you in those situations if we're talking about the same workers and the facts haven't changed. So use the determination, again, if you're not sure, or again, you want to get it in writing from our department. So with that, that concludes the information I want to give you. So now let me turn it over to our next speaker.
Good morning. My name is Eduardo Blanco. I'm an attorney with the Agricultural Labor Relations Board. Next slide, please. So the Ag Labor Relations Board protects the rights of workers in a variety of ways. And today I want to emphasize two areas. First, workers have rights and protections when they are unionizing. For example, organizing or supporting a union, and refer to that as union activity. Secondly, workers have rights and protections when they are acting together and raising issues to the employer about the working conditions, and we refer to that as concerted activity. The category of concerted activity includes bringing up issues of wages and hours and other examples of things that are working conditions or discrimination, harassment, health and safety. And this would now include any concerns they have about COVID, such as PPE, social distancing, and sick leave. The employer is required to respect these rights. And if the employer takes action against employees for exercising these rights, that is referred to as retaliation and is considered an unfair labor practice. Now, retaliation can be many things. It is typically thought of as firing employees, but laying off these employees before normal, or reducing their wages, or giving these workers less work, or giving them so much work that they quit are examples of retaliation. So clearly, if the issue being raised by workers is the fact that you are not doing something that is required by law, you are on pretty shaky ground if you then argue you are not retaliating. However, if you are doing everything correctly and they are they're asking you for something above and beyond what the law requires you to do, you have the right to say no, just don't retaliate. One last thought on retaliation. Words have meaning. Saying to employees, if you don't like working here, there's the door, can often, and has been often, equated to meaning the same thing as saying you're fired. Next slide. And these are the topics from this point on I'll be talking about, and about whether the ALRB applies to you. And so one issue is going to be, are you an agricultural employer? The other is, are you an agricultural employee? And the last is some of the requirements of the Medical and Adult Use Cannabis Regulation and Safety Requirements Act, MCRSA. So first thing to know is our law only applies to agriculture and only in California. Next slide, please. An agricultural employer includes cannabis cultivators, meaning cannabis nurseries, cultivation, and cannabis trimming. Under our law, if you are the owner of a nursery or cultivation or trimming business, you are an agricultural employer. It does not matter if you hire a contractor to provide these workers and to take care of all the HR issues. You are the responsible party for purposes of being held liable for any violations of those workers' union and concerted activity rights. And just so you know, in the case of agriculture, if you hire a contractor, that contractor must be a registered licensed farm labor contractor. And as you can see, the term employer is very broad. And I just want to highlight that it includes associations and cooperatives, so they can actually be held to be the employer and therefore liable for any unfair labor practices. Next slide. You heard EDD talk about who is considered an employee for their purposes and about independent contractors. And here's where there is some space between our agencies. Not everyone on the payroll is going to be considered an employee for ag labor relations purposes. Owners, managers, and supervisors are not considered employees. They are all managers. And that is regardless if they are your direct hires or are the owner, managers, or supervisors of any farm labor contractor you hire. Under our law, employees are the workers who are actually doing the touching the plant work, and that is their sole function. However, it also includes any workers who help ensure that the business achieves its goals of growing, harvesting, or getting the crop ready for market. So clerical office staff are also considered ag employees. So being classified as an employee offers protections, and it will also allow an employee to vote for or against union representation. Next slide. Labor peace agreements. I spoke about the violations of the workers' union and concerted activity rights. Labor peace agreements create situations where the violation of a workers' union rights possibly can occur. If you have a cannabis license, then you all know that you must have at least 20 employees at any point in the calendar year for these peace agreements to be required. And you must sign a labor peace agreement with any union that requests one of you. The agreement must provide that the union can come into the workplace and talk to your employees. And remember, this includes contractor employees. It is an unfair labor practice for you to ask your workers about what they think about unionizing, or asking about any particular union, or about what they talked about to the union organizers, or about what other workers said. Simply put, when it comes to unionizing, leave that up to your employees and the union organizers. Don't get in between. Because it's too often it's going to be seen as some type of interference and easily lead to an unfair labor practice charge against you. Now with COVID, you may be concerned about issues of social distancing, and it may lead to your acting unilaterally and telling the union they cannot come onto the property. I would say that can get tricky and handled the wrong way. It could lead to a filing of an unfair labor practice charge by the union against you. The best bet is to be proactive and talk to the union about your concerns and look for some middle ground, some way that they can talk to your workers. For a complete picture of what we do and your obligations as an employer or rights as an employee, our website is www.alrb.ca.gov. And with that, I will turn it back to our moderator.
Thank you. Thank you. Thank you to all the presenters for this great information.